So, if I can now introduce our panel of judges. We have the Honorable Presiding Judge, Timothy J. McJoynt, Honorable Elizabeth W. Sexton, Honorable Judge Robert E. Douglas, Honorable Circuit Linda E. Davenport, Honorable Judge Michael W. Reedy, and Honorable Ann Thoreau Hayes, and Honorable Susan L. Alvarado. I certainly hope I didn't miss anybody. I may have missed Judge Felice. So Honorable Judge Circuit Judge Richard D. Felice. I'm sorry about that, Your Honor. So before again we get into the questions, Judge McJoynt has some opening remarks that he would like to make that might cover a lot of the questions that might otherwise be typed in during this process.
Thanks, Henry. If you can't hear me, please wave or something. I can only see the speaker panelists, so I can't see all of you, but welcome. I want to thank Henry and Vicki and Wendy for setting this up. This is an outstanding idea. I understand the other floors are doing it now, following our suit, but we're first on. We're the leaders, which is great. The comments I'm going to make only apply to domestic relations courtrooms, which of course are most of the third floor, and of course 2001 and 2002 on the second floor. Other counties are doing different things. We've heard this a million times. Well, gee, Cook County's doing it that way. Well, maybe yes, maybe no. What we're just trying to do is to be clear as to what we're doing moving forward under these circumstances. The current situation is really governed by 3 time periods. And the administrative order came out Friday. I assume everybody's seen it. If you haven't, please read it as soon as practicable, because it's all there in much more detail than I'm going to offer this, today. The first time period is May 4th to May 15th, obviously starting today. We are still operating in a lockdown situation where there's 2 duty judges and 2 courtrooms open on the 3rd floor. That's it. The only thing the duty judges are hearing are emergencies, true emergencies, and orders of protection. They're also, of course, receiving agreed orders if they're signed by both parties and both lawyers. We're sending back a lot of orders, a lot of quadros. They're not signed by anybody. We don't know if they're agreed. So that's the protocol. Those are all prior protocols that we've already established, we've already talked about. I assume you already know about them. Those prior protocols include pretrials by phone. Somebody's jumping on. Here comes Judge Reedy. The protocols also include prove-ups without any testimony by affidavit. And then the third protocol that's in play that we've had for some time now are resolving pleadings on pleadings only, without argument, without testimony. That's our current status quo. It has been for the last few weeks. It continues to be that until May 15th. The new administrative order that came out Friday modifies our protocol starting today. It modifies it as follows. If you want a pretrial on Zoom instead of a telephone call, you can now do a Zoom. If you want to prove up on Zoom instead of by affidavit, you can do it on a Zoom. And of course, at a prove up with Zoom, you can cross and ask questions. Other procedures by Zoom are now permitted. What are other procedures for us? Presentments and statuses in hearings. Those are all now in play. The the challenge you have if you decide to pursue any of these activities for the next 2 weeks, you will still be in front of a duty judge and not your regular judge. If you're okay with that, then you can get to court right now and start setting up Zoom hearings pursuant to the protocol. The protocol is laid out what you have to do. You have to make a reservation, because once you make the reservation, then let's say it's a presentment in front of me, I then set up the Zoom and send you invites. Most of these reservations are being made in the afternoon because we feel like the afternoon is more time to devote to these, and you have to contact our secretaries to do that. This is all up till, May 15th. So the duty judge could hear a hearing, could certainly receive a presentment, could certainly handle a status. What the duty judge can't do for the next 2 weeks is set a pretrial or trial date for a case that's not his or hers. That's the restrictions for the next 2 weeks. So it's a little bumpy. The next, oh, and by the way, you're going to be receiving, all the lawyers I'm talking to, a 2-page document from Suzanne Armstrong, our circuit court administrator, on how to do Zoom. It's really nice, very, very slick. And if you really want to know more than you want to know, Kane County put out a 16-page Zoom protocol. Have fun reading that. Second section, second time frame is from May 18th to June 5th. May 18th to June 5th. All the judges come back May 18th. We're all back in the saddle, May 18th. Hearing our regular call, except only remote. So you still can't come in, lawyers. So what's going to happen? And the protocol lays it out, but basically, we're all going to be on the bench calling our cases. If no one makes a reservation or reaches out to contact us, we're going to give it another date. And it's going to be your job, the lawyer's job, to figure out the new date. It's a little better than before because before, as we know, the clerk gave arbitrary new dates. No control, no thought. 2 times it's happened in many cases. At least in this situation, your judge will give your case a new date, and presumably your judge knows something about your case. So that hopefully is going to be more efficient. During this period of time, from May 18th to June 5th, anyone who calls in ahead of time, makes a reservation, either for a phone call or a Zoom, they can handle the case, get something done on the case during this period of time. It can be either a simple phone call. We don't have court call yet. We've been trying to get it. Only Judge Davenport's the only lucky one that has it. The rest of us do not. It still may be coming. Certainly seems like a thing of the future. But if you want to handle a presentment or a status on the phone during this period of time, again, May 18th to June 5th, I'm sure the judge will be happy with that. If you want to make a reservation for a Zoom, for a prove-up, a hearing, we'll hear it. And your judge will hear it during this period of time via Zoom. All that can happen for this period of time. The one more thing I want to tell you is, as you look in the future and look up your cases, all the future dates given by the clerk are dates set for various things. They're not just set for status. So if you had a hearing on March 30th, and it's now June 30th, it's up for hearing. Same is true for the trial dates, but I'll talk about trial dates separately. So this is a time period for lawyers to come in to see their judge. Again, this is time period number 2 from May 18th to June 5th. This is a time where lawyers can come in on a Zoom 9:15, or what we used to call 9:15 presentment. We're not going to use those times anymore, and I'll get to that in a minute. You're going to come in a presentment and say, I want the case management judge. Gosh, is that trial going July 1st? Gosh, is my hearing going on June 15th at 9:30? You can get to your judges and find out, but you got to make a reservation for a Zoom. And of course, your opponent has to cooperate, which sometimes doesn't happen. That's the new normal for that period of time. There's a lot more detail. Read the administrative order. The third period of time is June 8th for I don't know when. Because somebody asked me this morning, how long are we going to do this? And I go, I don't know. I don't know. How long is it going to take for you all to come to the building and stand next to each other and feel safe? I don't know. But for now, our third time frame begins June 8th. We're open for business. People will then be coming into the building. That's, of course, unless we extend again. I don't know if that'll happen or not. There'll be social distancing and mask rules. It's part of the administrative order. There's no reason to think that we can't still do Zoom proceedings and phone call proceedings after 6/8. Why not? Maybe that's the way of the future. To stop crowding, though, in the building, I have dramatically changed the way we hear cases going forward. We cannot have 10 lawyers in a line outside 3009 on the 9:15 call going out the door in a long conga line. Those days are gone, at least for now. So when I talk about times for cases, I'm going to talk about pre-trials, prove-ups, presentments, statuses, and hearings. That used to be 8:30, 9:15, 9:25, 9:30. Those times are gone. Erase them from your memory bank. If you want a presentment, say it's a presentment. If you want a prove-up, say it's a prove-up. If you want a hearing, say it's a hearing. It will not be at those set times. It will be at a reservation time made by you ahead of time, which means statuses will be about every 10 minutes. We'll do them over like an hour. One case at a time. No more crowding, no more lines. Prove-ups are going to run from 9 to 9:30. We're only doing 3 a day. So if you want a prove-up, you may have to have a second and third choice for a date, because all the ceilings of number of cases all of us are going to hear are dramatically lower, because we have to spread out the call through the entire day, which means there will be delay because of this. Each case will have its own separate time slot, like making an appointment at your dentist. The caps will be lowered. The lawyers need to appear at your time that you were given or ordered. I know what's going to happen. We got lawyers who are double booked in multiple counties and multiple courtrooms. That's going to be a problem, because when I have a lawyer booked at 10:15 in my room for a presentment, he comes in or she comes in at 11:15. There's somebody else in that time slot. They got to come back another day. That's the whole point of this. We can only have one case at a time so that we don't have crowding. The issue is safety. And this is the only way I can see that we can ensure everybody's social distancing in our crowded calls, at least going forward for now. Hearings pre and post decree will be in the afternoons, Monday, Tuesday, Wednesday. We don't have any hearings in the morning. We don't have time. Once you spread out prove-ups, presentments, and statuses, morning's gone. Trials, probably only on Thursdays and Fridays. We're making Monday, Tuesday, Wednesday, everything else in trials Thursday and Fridays. That's going to really, really make extended trials hard to get done. The schedule and the protocol for courtroom 2001 and courtroom 3000B is slightly different, but it's the same approach. You can read that. Last topic, and I'm sorry if I'm too long. I apologize. Trials. Clearly, no trials before June 8th. I've heard legend that someone's trying Zoom trials. I think that'd be a challenge. It's not part of our protocol, so that isn't happening here. As to resetting your already set trials, and that's what everybody's all excited about, it is completely up to your judge, which means the sooner you get in front of your judge after May 18th, the better off you're going to be, because you're going to know, because you're going to be able to say, Judge, what are we doing? And then that discussion will occur. Can we still do this trial? What's the status of discovery? Do we have to extend the cutoffs? The Supreme Court has given trial judges complete carte blanche authority to do whatever they want with trial dates. They threw out speedy trial upstairs. So pretty much whatever the judge decides is in the best interest of your case is how this is going to go. I do feel many trials that are set in June and July will be reset, just because of this delay that none of us could imagine could occur and has now happened to us all. But you got to go in front of your judge and find out. The delays will push trials back. It'll be longer for us to get trial dates. I'm sorry for that. It will seem frustrating to some when you want to get a presentment slot or a hearing slot and you can't get it because the 3 or 4 or 5 slots for that day for that judge are already gone. We can't have any more cases because, again, we can only have one case at one time. Individual judges are being called upon to handle safety in their room when they come back and when you come back on June 8th, i.e., are we going to allow people to sit in the gallery? Every third seat? Are we going to allow visitors and guests? Are we going to limit the number of people in the room? Every judge is going to make those calls on their own, and they're going to basically have to enforce their social distancing protocols going forward. So you're going to have to know what each judge is comfortable with. It will not be surprising me to hear that a judge kick some people out of his or her room because it just was too many people. Because we got to remember keep our eye on the ball. What are we trying to do? Keep you apart from each other to keep you safe. So you need to ask your judges what sort of policing that judge will impose in his or her room on a status call or even during a trial. It'll be up to the individual judges. Okay, that was a lot. I'm sorry. Hopefully I answered some questions. Needless to say, going forward, this is a whole new world for our domestic relations community. I don't think it's going to be, well, I'm going to say this. It's the best we can do under the circumstances at this time. All right, Henry, back to you.
Okay, thank you so much, Judge McJoynt. And Mr. McCumber, we got your question and we're going to be answering it later on in the program. So the first three questions that we have are all kind of centered around trials, which, Your Honor, you just finished going over and discussing. But the first question that we have says, are end of May trial dates going to be automatically rescheduled, especially when trial statuses and pretrial conferences on those same cases have already been rescheduled to dates after the trial date? If not, what is the preferred protocol for attorneys to submit a joint communication to our trial judges to address continuing these end of May trial dates, if agreed to, in order to allow for pretrial conferences, extensions of discovery deadlines, and etc.?
Okay, that was me, right, Henry?
Yes, that is,
okay,
Your Honor.
Thank you. When you go on Ducks or check your cases, you'll see each case maybe has 2 or 3 future dates. That's because the clerks kicked a lot of these cases not once, but twice. And as they kick these dates, they go past prior dates that were set by us back in, before the virus. And so it is very confusing. And they're at our old times. So you kind of know what the date's for. Like, if it's a 9:25, you kind of know what it was intended to be. If it's 10 o'clock, you know what it was intended to be too. It was a trial. We're going to have to sort those dates out when you come to court and go through it. There's no magical answer for this. I can tell you that I already said there's no trials till after June 8th. So anybody's got a trial date in May, forget it. And so you come on the next date the clerk gave, the soonest date. And when I say come, if you're before June 8th, you can only come Zoom, right? You got to make a reservation. If it's after June 8th, you come and we'll discuss all those dates and clean it all up. But I don't know, is that responsive? Henry, you okay with that?
Yes, but I guess there might be one follow-up. So let's say that, and this is more along question 3 that Your Honor might have in front of him. But let's say that there is a date that's scheduled after June 8th. So if one of the parties through their attorneys come in and ask for a continuation, I think a lot of attorneys are wanting to know how likely is it going to be that a trial is going to get continued? Because on the one hand, it's going to be hard to schedule trial dates. On the other hand, it will have been very difficult for people to have prepared for trial with everything that's been happening. So how likely is it to get a continuation?
Well, without giving you an advisory opinion or speaking on behalf of my other 8 fellow judges, my guess is it's not going to be relatively hard to reset. In most of these cases, it's the only fair thing to do. I don't know what you guys have been doing on discovery. I know some lawyers have been working, some haven't. I don't know how you're taking deps. These are challenging times. So I think getting in front of your trial judge as soon as you can to ask him or her those questions is my best advice. My gut is I can't see a judge saying, you're going to trial May 15th. I don't care.
Okay. Now, as we've been talking, there's been 1 or 2 questions that have come in on this topic. So rather than waiting to the end, we'll just keep going on this one. What if an opposing party will not cooperate with getting a reservation? Or what if you have a pro se party?
Yeah, the administrative order has a protocol for that. If one wants Zoom and one doesn't want Zoom, both parties are compelled to submit a pleading to the judge within 48 hours, and the judge decides whether or not that Zoom's going forward or not. The issue is, of course, why are you resisting Zoom? Is it in bad faith? Those sorts of things. Because I felt that the judge should have the right to make the case go forward, even in that format, in appropriate circumstances.
Okay.
I don't know, is that?
Well, again, hopefully we'll have time for follow-up, and to the extent that we don't, we'll plan on having another, hopefully, judges panel later on in the month. But I think we're on to question 4, which, Vicky, is yours.
Vicky, unmute.
Can you unmute her?
Me? Nope.
All right, go ahead, Vicky. You're good now.
I'm now unmuted. So this is for Judge Douglas. If we have a case that is ready to be set for trial, it hasn't yet been set yet, can we secure a trial date now rather than waiting until the court's reopening? So would you recommend that we come in during the second phase, which is May 18th through June 5th, or do you recommend that we wait to come in?
Recommending, I don't know if I would go that far one way or the other, but what you can do starting on the 18th is you can, depending on when your trial date is currently set, and as Tim has said, it's kind of up in the air as to where those things are. You can come in on a motion to advance your case for trial starting on the 18th and ask for your case to be set for trial.
And then a follow-up to that is, if we are filing an initial motion and we'd like to present it, are we getting those dates from the judge's secretary? Is that laid out in the new orders, or do you have a better grasp of what that procedure is?
Having not gone through it yet, I have no grasp, but and I would have to ask Tim on this. My understanding is that you call and make your reservation with the judge's secretary.
Yes, that is a correct answer. That is probably now going to be the only portal to get a court date for domestic relations cases. Up to now, the clerk of the court has been able to issue dates. We haven't quite figured out if we're going to stop that completely or convert them to our new format. But your safest bet is to call one of the judge's secretaries to get that date and time, or time slot. It's sort of like Disney Fast Pass. Make your reservation and be on time.
And the follow-up to that on our question and answer is really with a pro se litigant. How will we know if the other party is resisting setting a hearing? Will you notify us? I mean, as you all know, sometimes pro se litigants don't send everything to the other side. So what's the protocol when we have a pro se litigant and they're resisting a Zoom hearing?
You want me?
Yes.
Okay,
Yeah.
sorry, I missed the first part, Vicky. I apologize. Any communication between a lawyer and the judge is ex parte unless the other side's copied in. So you should know right away if your opponent's objecting. I agree with pro ses. They don't know and sometimes don't follow that rule, but we suffer from that every day, don't we? Even in normal times. But in any event, you know, what will happen is the judge will have the obligation to get back to both sides within 48 hours and say, we're doing this or we're not doing it. And there's more of a burden on the judges on some of this stuff, but that's okay. We're big kids. We can handle it. We're going to probably be doing most of your orders. How about that? Look, because I mean, you know, we're kicking around electronic orders and all that other stuff, and that's just one more thing we got to worry about. But when we're doing remote stuff, somebody's got to do an order. I'd rather you guys do it, send it in to us. But if you don't, I'm going to have to do it.
Okay, so the next question is, I'm going to direct this one to Judge Davenport, Judge Alvarado, and Judge Sexton. If you could weigh in with regards to pro se litigation Zoom hearings at the end of this. How comfortable are judges with handling hearings via video conferencing? Should we bring them in by Zoom now, or should we wait until the courts are open? This question particularly applies to hearings that involve parties and third parties as witnesses.
Hi, everybody. I would prefer to wait until I can see people in front of me. I think that there's something helpful about having a body in the box as to the seriousness. The issue for me would be by doing it by Zoom, I don't know who's in the background helping that person answer that question. I don't know what documents they're looking at that they shouldn't be looking at. So that would be an issue for me as to why I would prefer to do it. Just real quickly, before I forget, as to the comments on the questions we were just answering on the trials, it seems to me, if I was still in practice, the thing that's most frustrating is the lack of control over what's happening with our cases and that we don't do anything. So I would suggest, as we've been doing the last 6-7 weeks on my cases, if you get both sides to email the judge, send an email to Judge Douglas or to Judge Hayes that says, we would like to have a Zoom conference, they're going to set that up. And then they're going to have their trial book and you're going to have your trial book. And you'll know that the clerk has given you dates for trial on the 5th, whatever. And you can strike those dates in an order, reset the trial date to a date that works for you, maybe July, August, whatever. But you've got the judge on the phone right then, and you're doing this by way of a Zoom conference. And you don't have to wait. You don't have to have clients come in. It's billable time now that you can work out. And we're all willing to do pre-trial conferences with you on Zoom. We've all been doing that. So I would prefer, though, to have hearings when somebody's in the box.
Okay, what about you, Judge Alvarado?
Well, I would say it depends upon the nature of the hearing. You know, that is what are we talking about? Clearly, if it's just a legal argument, if it's child support, something that we can do with just lawyers, then yeah, let's definitely get on Zoom as soon as possible. I agree with Judge Daff. If we have witnesses, it's very important, I believe, to have the witness in the box in order to assess their credibility and other things. But if it's just a straight up legal argument, you know, child support kind of stuff, by all means, I'm game to do it right away.
And Judge Sexton, what's the protocol for your courtroom?
We don't have any yet. We're not going to open till June 8, but I'm not sure what will happen in the 2 weeks before that. I don't really trust the pro ses on Zoom. I hardly trust them in the courtroom. So they need to be there. And it's hard to get hold of them. Some of them don't have phones. Many do not have computers. It's a technical issue sometimes with this population. So some of them are savvy and they can call in and try, but because I really can't contact both sides and my secretary usually can't get hold of one side, I'm not sure how it's going to work. It's really going to be trial and error.
Okay, thank you. So either I'm getting a notification from Wendy that we're getting a lot of questions. So we're going to let Wendy jump in and ask some of these questions that came in, and then Henry will ask the next set of questions.
Good for me. All right, so the next question is going to be for you, Judge Reedy. Can you hear me okay?
Yes.
Okay, good. I just hope you're not driving.
I'm going in reverse. I'm going through a fast food. Anyone want anything?
Big Mac, please. All right, so this question is, what is the critical mass of data or facts that would lead to an acceptable withholding of a child for parenting time? And then there's a little bit of elaboration here. For example, does the other spouse need to be diagnosed with COVID-19, have symptoms of the coronavirus, have been around someone who has it, goes to the grocery store every day without protective covering, or participates in things like open up the state rallies, or is like a frontline healthcare worker? Where is the critical time where it might become an emergency or it might lend itself to not permitting the parenting time?
All right, can you hear me?
Yes.
All right, you're gonna hate this answer. I think it's probably gonna be on a case-by-case basis. I think some of the things that are gonna be, you know, if someone is actually diagnosed with COVID, I think that's gonna be more of a red flag. I've started to do, and again, this is preliminarily, looking up some of the cases dealing with how courts have addressed quarantine situations in the past. There's the Barmore versus Robertson case out of Illinois, and then I think there was a U.S. District Court decision just recently in Illinois, and there's Lowell versus Massachusetts and Prince versus Massachusetts that talk about how, because there's a lot of constitutionality issues that come up, and again, I think it's going to be a case-by-case basis depending on what's happening. My quantum of proof, there may have to be a little bit of evidence. I had something the other day where at least one of the physicians had said, and again, we know from the executive order that travel between parties is one of the things that is exempt by the governor's executive order. But one of the parties had a letter from the doctor saying that he actually recommended parenting time or visitation to continue. So again, I don't want to give you that generic answer, but I think it is going to be really fact dependent. There may be, for me, a little bit of quantum of proof of hey, look at how is this kid really susceptible to any type of illness. And again, I'm not saying necessarily you need a doctor to come in and testify, but just saying, hey, I'm worried about COVID, that is probably not going to be enough to move the needle for me.
Could you, and I certainly don't want to put you on the spot. I understand that it's a case-by-case basis. Is there anything either in your mind or from what you've discussed with your colleagues on the third floor about some of the things that might push it over the edge where you'd say, yes, this is a situation where maybe parenting time isn't best? Could you give us some examples?
Yeah, I think one of the examples of that would be, I think on the floor we had a situation where the kid suffered from asthma or some sort of respiratory illness, or was one of the groups that it was the concern of COVID is one of those. It had one of the sequelae of suffering from something that, if exposed to COVID, could render that person either capable of getting the disease or possibly dying from it. Those are the ones that kind of are more the tipping point. And then if we've had some parents who were somewhat derelict that were, allowing a bunch of other kids to come over, or they were going back and forth to places where there was a bunch of parties not complying with the stay-at-home order. Those are things that are going to be more of our, things that I think, and again, I'm not trying to speak for anyone else but myself, but could be more of red flags for us that we may say, hey, look at, we think best interest of the child, or, this is now serious endangerment. Okay.
What about, and this will be the last question that I ask on this topic, and then I have a next one for Judge McJoynt. What about if it's something where a singular family member comes over to the home, or let's say a cleaning person comes over to the home to clean whatever, once a week or once every 2 weeks?
Again, I think I would analogize it to those situations we've had before where, with the analogy of like some sort of drug use and or alcohol abuse. I think there would have to be some proof to show that this is actually harming them. We can't just speculate. And again, that's where some of the cases that I've started to look at have talked about it is, obviously there's a very big concern over this, but I think it's dangerous to start heading down the path of, hey, look, at automatically because there's this cleaning person in the house, now we're going to suspend parenting time. I think that you run into a trick bag with that.
Okay. Thank you very much. All right, Judge McJoynt, if I can, I've got another question for you that this may tie in though to some of the things that you've already answered. So this is number 7 on our list of the questions that was submitted. It asks, can we have clarification on prove-ups or other electronic hearings where testimony is needed? And then there's a kind of a 3-part subpart to that. The first is, can the witnesses and the lawyers be in different locations? Can everyone log in remotely from wherever they are for a Zoom type electronic appearance? Or can we submit the paperwork and affidavit as under prior administrative order? I think that's kind of been answered, but I don't know if you want to elaborate on that at all.
Well, right now, Henry, you can do the prove up by affidavit, but then you are waiving your right to cross and confront and testify. If uncomfortable with that, then you have to wait till after May 18th, and then you can do a Zoom prove up. This is going to sound trite, but it's sort of a good idea for everyone to be in a separate place. That's why we're doing this. So it's certainly okay for everyone to be in a separate location to do a Zoom prove up. I think Judge Davenport indicated her reservations about maybe the lawyer and their client sitting next to each other doing a Zoom proceeding and what we can't see. So yeah, I'm much more comfortable when everyone's in a separate spot. I think it's very doable after May 18th.
The next follow-up to that is, can we conduct hearings with pro se litigants on the other side? Again, I think this has more or less been answered, and the answer is yes.
Yep.
Okay.
Yep.
And then can prove-ups proceed with a pro se, oh, excuse me. That looks like, can hearings be conducted? Not just prove-ups, but hearings. But again, I believe that's been answered.
I agree. I think, and the answer is yes.
All right, so the next question then is, given the likelihood of a resurgence of the virus in the fall and that the vaccine may not be coming anytime soon, are the domestic relations judges going to put something in place to allow for contested matters to go forward? Submission of exhibits electronically in Zoom testimony. Again, I think a lot of the administrative orders that were issued last Friday to some extent cover this, but I don't know if there's anything you'd like to add to it.
No, I agree. I think administrative order answers these questions, and the question really kind of suggests, how long is this going to be like this? And I already answered that one too. I don't know.
Okay. Two more. Again, these might already be answered, but we do want to go through the questions that people have submitted. If requested by both parties, will a judge accommodate a request for an oral remote prove-up via Zoom or telephone conference? Again, I believe that we've answered that with the administrative order, and that would be yes. Would you agree?
Yeah, I agree. And when you're on Zoom, we'll be recording you, so you will have a record on CourtSmart.
So, and that's great. I'm glad that you mentioned that. I noted that that the administrative order specifically covers the CourtSmart. So for all the attorneys out there, they don't need to make any sort of arrangements with CourtSmart or for a court reporter to be physically present. This will all be covered on the courthouse end as far as recording the proceedings.
Plus, private recording is prohibited.
Correct. So we're not allowed ourselves on our end to make any sort of recordings. I think I saw Judge Davenport raise her hand. She might have had a comment that she wanted to add.
Let's assume that you're going to be doing the prove up by Zoom and CourtSmart. And with what Judge McJoynt just said about having everybody separate, the invitation to do that prove up is going to be coming from the court after you've booked your reservation. And that means that the judge who's initiating the invitation is going to have the email address of your client so that your client can log on to the Zoom platform to participate in the prove up, unless they're sitting next to their attorney in the office, which shouldn't be happening. So if you're going to be doing a prove up by Zoom with CourtSmart recording, assuming you don't want to do it just by affidavit, you want testimony recorded, you're going to have to make sure that all the emails are necessarily given to the judge's secretary so that that information can be shared for the purpose of setting out an invitation.
Okay, thank you. Let's see. I think another question that just came in that might be related to prove-ups. It says, would the court prefer prove-ups continue without witnesses even after May 18th or after June 8th?
Sounds like my question. I think I made this comment before. These protocols that we've already established, there's been no request or push to get rid of them. So even after June 8th, I think you can still do a Zoom prove-up. Why not? I think you can still do a telephonic pretrial. Why not? If you're comfortable. And you know what? Some lawyers are still not comfortable coming to this building after June 8th, I'm guessing.
On that same note of the prove-ups, and I think a lot of people have questions about this, not just in the context of prove-ups, but also with hearings, and to some extent it might have already been addressed, but some people are wondering about default hearings. If they've done a motion for default or motion for a default prove-up, how procedurally should they move forward since they're not obviously going to have the participation of the other party?
Anybody else want it? I don't see any volunteers. Oh, Linda's got it.
We're not doing anything different with the law. So take us a reservation, send your notice out for that specific time. Make sure you change the body of your language rather than just say then and there move for entry of an order of default, whatever. My suggestion is if you're trying to do a order of default and prove up in stanter, that you, for one thing, don't say in stanter, say right then. And then also attach a copy of the judgment that you propose to have entered, which is always good advice anyway, so that they know on this date, if they don't show up, this document is being entered and they will be divorced at that time and that date. So just really good, bold language, bigger font, whatever to protect yourself, give yourself coverage to make sure that it's all included for that pro se, knowing that this is going to happen whether they participate or not.
Thank you.
And can I jump on, Henry?
Please.
The thought process for the lawyers, I think, should be if I default and go to a default prove up against a pro se litigant who didn't participate, you know, and along comes the 1401 and the defense is, gee, I didn't know how to get on the computer, or I couldn't get on Zoom. We may give you a do-over. So you really got to be really good and thorough on getting a default proved up.
Okay.
And actually, Henry, before we go on to our next topic, I'm going to stick with this topic and go to number 19 on our question sheet because we're just getting a lot of the same question. So after June 5th, if a court date is already scheduled and the attorneys want to do the status, the hearing, the prove up, whatever it is by Zoom, how do we go about requesting that since courthouses will be open at that time?
Okay, that's a new 19.
Yeah, number 19, Judge McJoynt.
Okay, my number 19 doesn't say that.
Oh.
Is there another question?
There was a revised one that went out this morning, but this one was assigned to you anyways, but do you have a recommendation for when we're back in court and we want to do things by Zoom? How do we let the court know? Is it the same procedure we're doing now?
Okay, yeah, it looks like question 21, Vicky, sorry. And yeah, I think that's fine. Again, I don't see any reason or push or request to get rid of these protocols. Some might suggest they're more efficient. I don't know, us old dinosaurs, we hate change. I get it, but you know, it's out there, and why can't you keep doing it?
And will it be easy if we already have a set time for our presentment? Is it an easy procedure to get a later time? Some attorneys are worried about childcare. Can we reschedule those times?
Through the judge's secretary making the reservation, making the dental appointment, yes.
So
up till June 8th, and then after June 8th, you just come in, right?
Right, and get your time.
Yeah.
Okay, so the next question is for Judge Hayes, and it is about the stimulus check that many Americans received. So here's the hypothetical that we received. The parties divorced in 2019. The husband retained the bank account into which prior tax refunds were deposited. In 2020, the husband received a stimulus check for both himself, his ex-wife, and their children. The husband refuses to give wife hers or any of the children's portions. Obviously, this is not addressed at all in the marital settlement agreement. So what can the wife do to have the husband turn over some of this money? And is this something that the domestic relation judges are dealing with?
Right. Well, clearly this is a one-time payment, these economic stimulus payments. So obviously there's not going to be any provisions for it in an MSA, and certainly we don't have any experience dealing with these. So if you actually look, I think it's informative to look at the treasury.gov. It actually has some really good questions about how the government has determined what bank account it's going to go to and how they're calculating the amount that's going to go to these bank accounts, okay? So without, I don't want to give an advisory opinion, but one of the things that I would look to is obviously in the example, Vicki, that you read me, they divorced in 19. So part of the question assumes, I would assume, that they did not file a tax return in 19. Because if they did file a tax return in 19, ostensibly it would be an individual return with their own bank account. So it would go to that person's account, so there wouldn't be an issue. So then, assuming that they're using the 2018 tax return, so I'm assuming that's part of the question, and it went into that bank account. You know, it's a good question whether we even have subject matter jurisdiction over this, because this is some federal money that's coming to these individuals. So if you actually look at the documentation, it says that eligible individuals will receive $1,200. 2 eligible individuals filing a joint return will receive $2,400. So assuming it went into the right bank account, and there's not an issue there, I would assume that we're going to get some motions regarding this where it went to the right account. It's not a mistake that the federal government made. And I think, without giving an advisory opinion, I think the Treasury's information is pretty informative, because the way they're looking at it is essentially $1,200 per individual, and obviously that's the maximum. Part of the question also talks about the money that's coming for the children. And if you look at it, it's based on who claimed that child as a dependent in that particular tax year. So again, I'm sure we're going to get questions about who should get this money, because if you have the 50-50 shared parenting arrangement, and they're alternating tax exemptions or dependent in their MSA, and they're not behind on child support, it's a fair argument to say, how are we going to divide this? And one parent shouldn't be keeping all of that money. So to answer your question, I think some of these situations, we are going to see motions filed if they can't work it out themselves. Obviously, keep in mind, the most that we're talking about is this $2,400. That's the most. It goes down by a 5% percentage based on the increase in their income. So hopefully that answers a little bit about question 9, Vicki.
So that question dealt with divorced couples. Now, same issue, same stimulus issue. The parties are still married, and one party grabbed that stimulus payment before the other party, or they filed a separate return, so it went into one account and not the other,
Right.
actually the children's portion.
Yeah.
How's the court going to deal with that?
I think that question's a little bit easier because we're predisposition, and I don't want to speak for my fellow judges, but that's income or money that the marital estate is receiving and is going to be subject to division. That's a little bit easier because we have the ability to handle that in the dissolution. And I think it's clear, whether it's an individual return, like I said, or the double for the joint return, it's clear that they're still married. It's funds that the marital estate is receiving, and we're going to take care of that. That's going to be divided, whether they agree to it or we're going to do it at trial. So I think the pre-dispo cases are a little bit easier than those ones where they're using these old tax returns and the bank accounts have changed. They're not married anymore. Those are a little bit more, I would say, complicated.
Great, thank you. Henry, you've got the next one.
Yes, thanks. So Judge Felice, this is for you. You can hear me okay?
I can. Thank
All
you.
right, wonderful. So obviously a lot of people are losing their jobs, and we have one of the highest unemployment rates in history. The question is, do we need to file motions to modify support? In other words, what I think the person asking the question is trying to get at is, if they don't file a motion to modify support because they don't want to spend more of their client's money, especially when their client is out of funds and no longer employed, what are the chances that the court is going to hold them in contempt?
Okay. Well, thanks, Henry. I think obviously the best course of business is to file a motion to modify. I think without doing so, it still presents a number of problems aside from contempt and as to whether the court can do anything about that which is already accrued, and that's a problem without having a motion on file, as we all know. With regard to having a motion on file versus not having a motion on file, I think it all depends. If you have it on file, safer bet, but it all depends on what other sources of income were available, what other, it's a pre-decree case, post-decree case. Is this person getting other money? Can they afford to pay something? If they paid nothing, are they just simply taking the attitude of, well, if I've been furloughed, I'm not going to pay anything. Are they looking for other work? Is other work available? So I don't think it's as simple of an answer that, look, I lost my job or I've been furloughed, I'm just not going to pay. So I guess I don't have to worry about being held in contempt. I think that would be a really bad idea and be fraught with a lot of risk, particularly in the individual case. And it's going to depend on each case. I don't think there's any one size fits all, but I do think it should be, I think, a fair warning that somebody cannot simply take the attitude that just because of the situation the way it is, I'm not going to worry about paying my support because I guess I won't be held in contempt. I think that would be very bad advice. And I think under some circumstances, it's possible they could be held in contempt. Without knowing the facts of the case, it's going to depend on each one.
Okay. So to recap, it sounds like there's no one blanket answer. Obviously, it's going to be a case-by-case basis. But there could be a circumstance in which someone could be held in contempt. But the ultimate advice is that a motion should be filed if someone believes that a modification of child support is in order.
Without question. I think it would be prudent for every lawyer to encourage having a motion to modify be filed by their given client, whether they're going to do it through the attorney or otherwise. I think it would be very bad advice to suggest that if they can't afford it, then don't worry about it or you'll deal with it later. I don't think the laws change relative to not filing a motion to modify and the support being accrued. Now, there could be other issues that could be raised as well, but that's just a no-brainer, I think, to start with.
Okay. There's a follow-up to that question, and I think to some extent you've addressed it, but the question asks, is there any situation in which the failure to pay child support could be deemed an emergency?
I think so. I think it's possible. Without addressing what happened in other cases, I've seen this happen already as an emergency duty judge where people come in under dire circumstances. I think it all depends again. Is it a pre-decree, post-decree case? Are there funds available that are just simply not being used by the person that's claiming that's an emergency? You know, if somebody comes in and they have $5,000 sitting in the bank, but they really don't want to use the $5,000 right now, and they are upset because they're not receiving support, is that an emergency? Versus a situation where there simply is no other funds available, there's no credit available or very limited credit available through credit cards or other means, and they're not able to even buy food or afford their housing, then I think that is a different situation. So it's a case-by-case analysis. It depends on the totality of the circumstances as to whether it gives rise to whether it be an emergency or not.
All right. Thank you very much, Judge Felice. All right, Vicki, you've got the next one.
Yes, so Judge Douglas, how will the court address contempt petitions for a parent not following the parenting schedules? This particular person wanted to know what relief will the court grant? Other counties have indicated that parents would not be held in contempt if there was a good reason, but that makeup time would be granted. Has DuPage County discussed how we will be handling these matters?
Have we discussed it? No. But obviously, and I hate to sound like a broken record as some of that, these are all going to be very fact-driven, case-by-case analyses. And in this case, I mean, we have to look and see, is the conduct willful and contemptuous as to saying whether or not we would grant contempt. You know, if there's a good reason, as the question indicates, for why the parenting time was not complied with, well, you know, then that would kind of argue that it's not willful and contemptuous. As far as the whether or not makeup time would be granted or other remedies, certainly makeup time is one of the things in our arsenal, and probably if we're not going to be looking at other things, that would be the most effective thing to do. But it's going to be on a case-by-case basis and a judge-by-judge basis.
And I'm assuming this will be case by case and judge by judge, but the follow-up is it an emergency if a parent is refusing to follow the parenting schedule and a client is not getting parenting time?
Is it an emergency? Unless somebody is in danger, probably not. You can bring it on the regular motion call, but you know, everybody should know what the standard for an emergency is, and pretty much it is imminent danger to somebody. So given the way you read the question, probably that wouldn't be an emergency unless there was some imminent danger.
Great. Thanks, Judge. Henry, you're up.
So, Judge, a couple more for you. And again, the next one is probably one that I think you've already answered. Am I muted or am I okay?
You're unmuted.
Okay, good. So it says, what is the procedure for getting a default prove-up done? And I think Judge Davenport has already chimed in on this and, you know, said follow the normal procedure. The person asking the question said, usually I would be able to file a motion, give the other side notice, and get a prove-up done on the date of the motion. Can this be done remotely? And again, I think the answer is yes. The only procedure I saw was for prove-ups where both parties signed the affidavit. But this question, in fairness, was asked before the courthouse issued the administrative orders last Friday. So is there anything that you'd like to add to that, Your Honor?
Yeah, you know, Henry, recent article, Family Law Section Council, the Illinois State Bar Association addressed perfecting defaults and the rather involved procedure for sending notice of a default to a defaulted party, which is always one of those defenses down on the second floor in small claims when there's a creditor going after a debtor. We don't talk about those things much on the third floor because the Code of Civil Procedure still applies to defaults on the third floor. Last time I checked, I'd just suggest all lawyers check that out and make sure you follow that procedure to some extent for more insurance that your judgment doesn't get vacated later.
Okay. Again, the next one, you know, as I've mentioned quite a few times, some of these questions or a lot of these questions were submitted prior to last Friday, but it asks certain Cook County judges are starting to make all court dates mandatory. By that date, the attorneys either have to submit an agreed order with a status, agree to a hearing date, agree to briefing schedules, or do a Zoom status with a judge. The biggest hangup so far on many of the cases in DuPage County has been one side not wanting to move things along and being unwilling to contact the judge. So can DuPage institute, to the extent I guess it hasn't, a procedure wherein we have a regular status call or even file motions that aren't emergencies that can then get an automatic briefing schedule? And again, a lot of this I know has already been answered.
Yeah, I think a lot of it has. I can tell you that all of us will never let a pre-decree case leave our room without a future date. So we kind of police you that way, I guess. Post-decree, not so much. So all these pre-decree cases have future dates. And as I said, on May 18th going forward, we're going to be calling those cases. And we hope to hear from you. But if we don't, we're going to give you other dates. And presumably the new date's going to be after June 8th. And then if you don't come on that date, then we are probably going to have a problem with that lawyer or that litigant.
So let me follow up a little bit on that. So let's say that we have a date now. So May 18th, all the judges will be back in their courtrooms, but we'll be handling things remotely. So let's say that we currently have a date scheduled for, let's say, May 18th. We're obviously not coming to the courthouse. Do we need to do something in order to keep that May 18th date?
Yeah.
Or will judges automatically be sending out a Zoom invitation to the attorneys?
No, you have the laboring or. If you got a May 18th status date, and you want to talk to me on May 18th, you got to make a reservation with my secretary before May 18th for either a telephone call or a Zoom hearing proceeding. If not, nothing's going to happen other than I'm going to give that case another date.
Okay, so for all of us who had those dates then between May 18th and June 5th,
yep.
Not enough that it's been continued to that time. We still have to go in, have the laboring or contact the legal assistant that's working for Your Honor, and then make sure that that's scheduled for a Zoom conference. If we do that, at that point, then will Your Honor then send out the Zoom invitation to the litigants, to the attorneys?
Yes, if you give me the right info and you agree on a time, on that day for that proceeding, then I will send out the invite to all the emails you gave me.
Okay. Now, if we can't reach the agreement with the other side, we say, listen, we've got something scheduled for May 18th. I want this to proceed forward, but opposing counsel isn't taking the call. Opposing counsel isn't agreeing to the time. What then?
Well, I assume you have the opposing counsel's email. You give me opposing counsel's email, unless I hear from opposing counsel, I'm setting it up. Then the opposing counsel is at peril if they don't participate.
Okay. I have one more follow-up, and I'm sorry, I'm throwing you a little bit of a curveball here. This isn't in the one that you've got in front of you, but it's something that just dawned on me. Let's say this is a initial status date, and one of the litigants was planning on filing a substitution of judge as of right. How will that get handled? Well,
that is a curveball, but very frankly, Henry, I've been fielding curveballs for the last 3 weeks, like every day. A couple things. All these cases have multiple future dates because of the automatic extensions of the cases. Don't forget, lawyers, to address the case on the most earliest date. Don't assume, oh, that date got struck, or the real date's the week after that. Don't assume that. What I'd like you to do is surface in some fashion on that first court date so we can get rid of all the other dates, clean it up, because all these cases are a mess on future dates, I guarantee you. As to the SOJ request, that procedure is like any other presentment and will be handled like any other presentment. Now, a presentment between now and June 5th, you got to make a reservation. And if you do, and you appear in front of Judge A, and Judge A basically is presented with an SOJ as a matter of right, case goes to me. Nothing else is going to happen that day. It's going to come to me, and I'm probably going to reassign it, and I'm probably have the obligation to tell you what happened, because I don't know, we just haven't invented a procedure for that. Now, after June 8th, you're here. And so that would be more business as usual, whatever that is. I hope that's responsive.
Okay, no, it is. Thank you. One more follow-up that someone just texted in or wrote in. The reservations that we're talking about when we're contacting your assistants, do they have to be over the phone? Someone's asking if we can email your assistants as well.
The problem with that is it requires some cooperation between you and your opponent, doesn't it? Because you want, I don't know, June 1st, and they want June 2nd. I'm just picking those dates out of the air. So you can, I guess, if you want to email us and say, here's what we want, but it still requires you to get a slot from the scheduler. So emailing, you don't know what slot you're going to get. If you want to just roll the dice, okay, because it'll be up to the scheduler to pick your time. If you call, then you'll have input on that time. If you simply email, you're going to say, I want June 1st at 10 o'clock, and you might get June 1st at 2:30.
Okay, so it sounds like Your Honor's advice is best procedure would probably be to pick up the phone and call.
I think so.
Okay. All right, Vicki?
Yes, this one is for Judge Davenport. Many graduation ceremonies are being pushed to the summer. Does that mean child support should continue?
I don't think the statutes change. So it's only one. So I would say it goes when the graduation or age 19, whichever occurs first. I'm not changing anything. So if the ceremony goes long, they haven't graduated. If there's a school though that says that a child is graduated and they get their diploma and they don't have to walk, that's a different issue. If they've got their diploma in my book, then they've graduated. The walking isn't the issue. But if they don't have a graduation ceremony or a certificate or diploma, then I'm going to do it when they actually get it.
Thanks, Judge Davenport. Henry?
All right, Judge Sexton, this one's for you, if you can hear me okay. All right. So I know that there's been some comments on this already to some extent, but all of the domestic relations directives are primarily, it seems, geared toward attorneys. So will there be any special considerations for pro se litigants in light of our access to the to the courthouse?
It's going to be a work in progress, Henry. I don't really know how it will work for them. A lot of them will miss their notices. They move around a lot, and some don't have permanent addresses that give parents or family members. I'm going to be very lenient on missing court dates and giving new dates for about 3 months at least. But they're going to have to call in like the lawyers. They're going to have to follow the rules. I just got word today that we will still be in 2002, which we had not contemplated. So that room is very small, and I am really going to be adamant about one case at a time being in there. I'm not going to let people sit in there. They're going to sit somewhere else because it is a very small courtroom. They're going to be way back from the bench. I don't know how I'm going to see their documents. I don't want to handle anything that they have. So it's going to, for a while, going to be on a day-by-day basis. I don't know.
Okay. Okay.
Tim, you got anything else on that?
The challenges you face, we also face. I think all of our little desks in front of our benches are all pushed back now halfway across the room. So handing up papers is now, you can't. So now what do? Give it to the clerk, give it to the deputy, they give it to me. Lots of little things like that are going to be bumpy.
One other thing, my clerk, Karen, was very involved with the pro ses and getting them the right documents, getting them ready. I will not have her do that. I'm probably going to have our sheets showing them what they need in the library. They're going to have to fill them out. They're going to have to go to the library and do it themselves. And I don't know what the library has planned to assist the pro ses in this kind of an environment. And they are a huge help.
Right now, the library and the pro se assistant desk are both closed.
Okay, well, that'll be interesting. So what I think I need to do then, and this is just a new thought, I'm going to need to have the forms, the judgment, parenting agreement, and what else? Everything that they're going to need has to be in the courtroom. But they will need a spot where they go do their child support calculations, because I told them, you're your lawyers. You have to do it. I'm not doing it for you. Otherwise, they're getting free legal advice. So I think it's going to be very problematic for about 3 to 4 months until we can kind of get into some rhythm. And I think it'll change on a day-to-day basis. If you have any helpful instructions, let me know.
Okay.
Okay, Judge McJoynt, this is really a procedure question. So let's assume somebody has a hearing on May 18th and they made their reservation and they have their time. The hearing is obviously by Zoom, but there's quite a bit of exhibits. How do they get those in? How do we submit those electronically? And how far in advance of the hearing do you want those exhibits?
Yeah, you already stumbled on a missing piece of the last administrative order. My bad. You try to cover everything and you forget something. We have a rule when you submit electronically pleadings, there's a limit because the county doesn't want to copy 150 pages when you submit 150 pages. And so I guess the number of copies that you submit, be it exhibits, pleadings, or whatever, is going to be an issue if it's voluminous, because the people that receive those things from you, if it's over 25 pages, they're not doing it, which means the lawyers have to bring it in, hard copy, drop it off, FedEx, mail it, whatever, and get it to us. But if it's a bank statement and it has 20 pages, I guess, you're going to have to copy it and get it to me. And then Judge Hayes just brought up how far in advance. Before the hearing would be great. And remember, if they're exhibits, I'm not even looking at them until they're admitted during the Zoom hearing.
Right.
And if they don't get in, they go in the garbage.
Okay, thank you. Henry.
All right, Judge Alvarado, the next one is for you. So it says, what do we do if we have multiple court appearances scheduled at the same time in different courtrooms. So for example, how do we let the judge's clerk know to put a case on quote unquote hold so that if we're late or tied up in another virtual courtroom? And then,
Okay, well, this is going to be a universal problem, yes. As some of the other judges have alluded to today, you know, we're going to be learning as we go. But here's what I can tell you about courtroom 3007. We are going to have appointment times, and we are going to adhere to those appointment times as closely as possible. What I would suggest to you, I mean, the idea that somebody is going to contact the clerk and put the case on hold, I don't know how that happens, because as Tim mentioned earlier, if you have let's say you have an appointment at 10 minutes after 10, and you're stuck in another courtroom or another county or whatever, and you call my clerk and say, oh, heads up, I'm going to be a little bit late. Well, I've got somebody else. My whole day is booked. So it's going to be really tricky. I certainly am going to be as flexible as I can with the attorneys. And if you're going to be late, hey, you know, I hope that there's a hole in my schedule that day and I can slide you right in there. But, you know, I don't know that we have a procedure at this point as to, you know, how you sort of call and say, I'm going to be late. I think that means that you've missed your appointment and we're going to reschedule you. That's the most likely outcome of that. But again, this is a universal problem. We're going to see a lot of this. So we're going to work with you as best we can. What I would say to you is try your level best to keep your appointment times. I know when I'm on the bench, you know, if it's a 10-minute meeting, I'm going to hold you to that. I'm not going to go over an extra 5 minutes or an extra 10 minutes. So I think we just all have to just try and see how it works. And another thing that would be a recommendation for me is be realistic about your hearings. If this is not a 20-minute hearing, what we used to call a 20-minute hearing, say a 9:45, you know, then don't put it on that slot. You know, be realistic about your hearings, how long they're going to take. Don't go overboard. It's going to be really sticky. But I guess the best thing I could tell everybody is if you have a 9:20 appointment in 3007 and, you know, you're stuck in Judge Reedy's courtroom at that time, you know, maybe just let Judge Reedy know that, you know, I've got to go or I'm going to miss my other status, whatever. That 10 minutes is yours and I'm going to hold it for you. But after that, I can't promise.
okay. So you have actually touched on two other questions that we have, and that is, so what happens if your opposing counsel then misses the court appearance? So will just a new date be issued, and will there be consideration given to the attorney who has appeared?
Well, from my perspective, it is going to be a case-by-case analysis. You know, what's the reason? Why isn't the other attorney here? I think the same rules apply, you know, as they used to apply. You know, if you make a good faith effort to be there on time and the other attorney has not contacted us, we don't know what's happened, you know, then yeah, I think that the attorney that showed up on time, you know, you kind of get to make the call.
Okay. And then you have, I think to some extent, answered at least a portion of this in your comments earlier. The time slots, those are going to be for 10 minutes for statuses?
I believe so. Is that right, Tim? We didn't hear you, Tim. Is that right?
Oh, yeah, she got me unmuted. I'm unmuted. Let me jump in. Sorry. Pre-trials are 15-minute slots. Prove-ups are 15-minute slots. Presentments are 5-minute slots. Status calls are 5-minute slots. Hearings are 20 minutes again, pre and post. And so, we're just gonna start the clock working and for example, prove ups is 3 a day, 9, 9:15, 9:30. Presentments, 5 a day, starting at 9:45, 9:55, 10:05, 10:15, 10:25, Monday, Tuesday, and Wednesdays only. It goes like that. I hope that's descriptive enough for everybody to understand.
Okay. And this is the schedule between May 18th and June 5th or 8th?
June 8th.
June
No.
8th.
No, it's a schedule till further order,
Okay.
before and after June 8th.
Okay.
It's the new normal, Henry.
And for things like a contested trial, when we're looking out towards, July or August, or beyond that, I saw that, I think those are going to be scheduled at 1 o'clock. Do I have that correct?
Trials are generally on Thursday and Friday at any time your judge wants to set it.
Okay.
Your judge is completely in charge of their own trial call.
And that would be including the length of time that it's scheduled for that afternoon?
That would be something for the lawyers to tell the judge, and then the three of them schedule and come up with a plan for when they can successfully try the case in total.
Okay.
And one of the follow-ups to all of the time, or all of the time slots are, if we run over our time slot, we have to get a new date, I'm assuming. We don't get to keep going, correct?
Yeah, if there's somebody behind you, yeah.
Okay.
Okay.
There's been a question regarding the time slots, which is if we've got dates scheduled already, May 18th going on, for even in June 8th, people are supposed to call and secure a time slot going forward. They should not assume they get to keep that June 8th date unless they get a time, correct?
Yes.
And they have to call to secure that time or another date in the future, depending on the court's availability.
Well, kinda. If you have a trial date on June 15th, it would be really smart if the lawyers came in before that date to talk to their judge about, is it going or not? If the clerk gave it another trial date down the road, same problem. Is that new date the clerk gave out, is that gonna work for everybody? Chances are probably not, but if everyone can try it on that date and they all wanna try that date, why not try it? But I think the vast majority of this is going to be resetting.
And so if there's 7 statuses set on June 8th in a particular courtroom, people should be calling to figure out if they're going that day. Same thing for presentments or hearing slots.
Yeah, you understand this new system of one case at one time is not going to work right away. Like, we can't flip this over overnight. So our remnants of our old system, 10 cases at 9:25, 5 cases at 9:15, we will still have going forward for about the next 60 days, obviously. So for the next 60 days, we're going to have some cases spread out, some cases not spread out. It's going to fall upon the individual judges to make sure the room does not get crowded and police social distancing. That's how it's supposed to work. Fingers crossed.
Which somebody asked, what are they supposed to do? Are they supposed to wait in the hallway till their allotted time? And if their clients come with them, are they witnesses? Are they all supposed to wait in the hallway?
Yeah, I know I'm maybe kicking the ball down the road by saying go out in the hall and with all the other people hanging around out there. They got their challenges too. And there's no question about it. And hopefully everyone's going to be masked. Everyone's going to stay away from each other and do the best they can do. But, yeah, and you know what? I've been just joined by Chief Judge Guerin, and he wanted to remind you all that, 6/8 could get extended again. Oh God, I know, yeek. But this is the plan for today. But these plans have been changing dramatically the last few weeks, as you all know.
Thank you, Your Honor. And you can thank Chief Judge Guerin for us as well for reminding everybody of that. We appreciate that. If we can move on from that question, unless there's any other comments to be made, there's another question for Judge Reedy, if we can address him. So the question is with regards to guardian ad litem. Sorry, Judge McJoynt, did you want to say something else?
Wait, we have to unmute you.
Okay, no, Henry, I'm okay. Thanks for asking.
All right, so Judge Reedy then, the question is with regards to guardian ad litem. So do the judges expect guardian ad litems to do home visits during the month of May? I'm anticipating the answer is probably, but then maybe to elaborate on that is there any advice as to what you would like to see?
Yeah, I guess I'm speaking for everyone else. I don't think any of us are expecting anyone to be able to, can you hear me okay?
Yes.
That we're expecting people to be able to go into other people's homes. But by the same token, if the GL is comfortable and the parties are comfortable and they want to be able to do that, and if they're able to wear masks or something, I'm not going to ever stop someone from doing it if they're able to get something accomplished, especially if there's something urgent. What they could potentially be doing, you could potentially have a person on FaceTime or Skype, potentially walking around the house, if it was some sort of home visit they were looking to do. Obviously, and I hate that expression, thinking outside the box, we're all trying to think of different ways we can accomplish the same thing. As the GL, putting that back on the guardian ad litems, the guardian ad litems are all fantastic in our county, and we all rely on you. And if you don't feel comfortable, either A, going to the house, or B, doing walking around with the person walking around with a phone showing you their house, we're not going to expect you to do that, and we're not expecting you to come back and say, I feel I'm done with my investigation because I was able to, just have them show me around their house by using a cell phone. So at least in my courtroom, I'm going to give more leeway. And then the only thing that could potentially change that is depending on the emergency. If there was something, that was urgent before the court, or we were in a situation where there was a child seriously endangered, that's where we may have the jail and the court would try to have a kind of a more or less a meeting of the minds to try to say, hey, look, what do we think we can do to accomplish this to get the investigation complete?
Okay. I presume many attorneys, as I am right now in a particular case, are dealing with the issue of many witnesses we can still speak to telephonically or something like this over Zoom. However, when it comes to the children, or if you're in front of Judge Gibson and you're dealing with a disabled adult, oftentimes people don't want either of the parties around either the children or the disabled adult because they're afraid of influence. And so the way that we've dealt with that in the past is to, again, had time where just it's us with the children. However, if the parents have concern over, COVID-19, they may not want that. Has Your Honor or any of the other judges considered maybe appointing parenting coordinators to maybe assist if one parent's saying, listen, we need to get this resolved quicker, and the guardian ad litem can't meet directly with the children and not comfortable doing it over Zoom?
It's obviously something that is at their disposal. The worry with parent coordinators is the added expense. So if, it's depending on the financial makeup of the parties, if they're able to afford something like that, yeah, obviously it's something, another tool in the tool belt. But if it's something where, we barely have the parties being able to pay their guardian ad litem, it's obviously, I think that is more of a luxury that we may not be able to apply in that particular case.
Okay. Thank you very much, Judge Reedy. We are at the end of the questions that have been submitted to Vicky and Wendy and I. Some of you may have been typing in questions as we've been going along. We've tried to address them as best we can. Wendy, do you have any that you wanna ask or follow up on that we didn't catch?
There are a few.
Okay.
And the first one would be, when should people start calling to secure times beginning May 18th? Let me unmute Judge McJoynt.
I think we want to ask Judge
McJoynt?
No.
Okay. And then somebody wanted to know if it's possible to do still prove ups via Zoom or phone call. And would you be able to do more than just 3 a day if they were done that way?
There's two questions there. The protocol allows for either a prove up by affidavit, the old protocol, or a prove up by Zoom. I'm not doing a prove up by telephone.
Okay.
We got to see the faces, or they got to waive that and do affidavit. What was the other question?
Whether, hold on, I scrolled away. Whether that was going to continue after June 8th.
I think Zoom prove ups can continue after June 8th until somebody says, I don't want to do that anymore. Judge Davenport's got an answer, I think, too.
The first part of the question that you didn't hear was, can we do more than 3 a day?
Oh.
And yes, we certainly could. If you're doing them by affidavit, that we can sign as many as you'd like. But if you're looking for a Zoom one, just call, set up a time with the judge's secretary, scheduled one. Here's a good example. Let's say that in the next couple weeks, we don't have cases on every one of our slots, okay? Call and ask the secretary or the assistant, hey, does the judge have time at 2 o'clock or 3 o'clock in the afternoon to do a Zoom prove up? And if we don't have cases, we're going to be doing a lot of sitting in our chambers sometimes. All of us are going to be willing to do a Zoom prove up or something. So give us the opportunity, be flexible, be prepared when you call in with all those emails so that Judge McJoynt or I or whoever can send out that invitation to do a prove up at 4 or at 3, whatever you decide to do.
Agreed.
So going with this, people wanted to know if they have a draft order or partially completed order, do they want those submitted in advance of a court date? Since oftentimes the judge would be preparing the order, even if it's not finalized.
If you want to send a proposed order along with your other pleadings, happy to take it. Be one less thing for us to draft if we agree with what the order says. Linda, Judge Davenport.
Lawyers on my pre-trials that we've been doing the last 2 months send in an order that says the case is set for future status on, and then they list 5 days or 4 days. And then once we agree on what that one is, then I send the duty judge the order that says this order is fine. Please circle June 5th, like the other 4. And that allows everybody to know that this is the final. And I tell the lawyers, hey, go on ducks in 2 days and then get a copy of the order.
Judge Reedy.
Can you hear me?
Yep.
The only thing I would like to add with respect to the prove-ups by affidavit, I think Judge Hayes is as well. I've rejected a few just with respect to when it's a pro se on the other side and a waiver of maintenance. Just include what the parties are making, just so because it just feels a little bit uncomfortable with a waiver of maintenance when one side's represented and one side's not. So I think a couple of parties have addressed that and put the incomes of the parties if there's a mutual waiver. So the attorneys just, if it just will, I'll most likely go along with it, but I just would like to know that it's not some sort of undue influence.
One of the questions is, can the court compel a party to submit to a Zoom deposition?
Let's have Judge Douglas answer that because Judge McJoynt is missing in action. Let's unmute him. There we go, Judge Douglas.
Well, I think we could, since we have the ability to say that they have to appear for a video evidence deposition or something like that, yes, we could order them to appear for a Zoom deposition. Do you disagree, Tim?
No, I agree. I don't know if I want to take a Zoom dep, but I don't know if I want to take a Zoom dep. That's up to the lawyers. But I think we can compel.
Yeah,
we certainly have the right.
We compel.
Can I jump in, Wendy? I apologize. Judge Guerin just notified me of something else that literally just happened this morning. So this is never changing. This mostly affects Judge Sexton and Judge Cerny's call. The clerk has developed a notice to go out to the pro ses to their last known address, which may or may not be correct. Advise them how to contact the court and to set up a remote proceeding. So, It may help. I'll get you a copy of the notice, Judge Sexton. I haven't seen it yet.
Are clients allowed to be present on the Zoom calls for statuses?
Anybody? I think we'd all say yeah.
Yeah, I mean, they could be in court with you, so why not on Zoom?
Great.
What about translators? How are we addressing people who require translators? Sorry,
Ouch.
it came in live. I can't help it. It wasn't pre-planned.
It's a real, Wendy, it's a real problem. They're having a heck of a time in the fourth floor because it's up there more than down here. Right now, we're still doing the order that, requiring the translator to be present. And it really depends on the type of format. Is it a Zoom or what are we doing, And we try to get that person in the loop. This has not worked out really well, I'll be honest.
Somebody asked a question, considering that not all individuals are very tech savvy, how will the court accommodate the people who do not have access or the ability to appear via Zoom?
Okay, well, yeah, that's a real problem because, well, as we all know, people who don't have a laptop at their house, they go to the library. But we all know the library's closed. And then they go to the law library and get help there, and they're closed. There is no question in my mind that the self-represented litigant population is being negatively affected by this process. All we can try to do is to get them to somehow find a way to get online, at least till June 8th.
Most of them are pretty good about calling. They know how to call. And depending on who my secretary will be, we'll have to deal with them.
Good point.
I just wanted to add something else if I could too. Vicki or Henry?
Yes, please.
Yeah, go ahead.
Okay, so two other points to be noted. In the current rules, and this sort of ties into the question of the technology and availability, if the judge feels that the Zoom hearing is not going well, there's video loss, audio loss, judge can terminate the hearing at any point on the basis that it's just not working within their discretion. The other issue that came up earlier about exhibits, the rule does indicate that 7 days in advance or prior to the remote proceeding, the exhibits that were intended to be introduced should be electronically submitted to the court. And I know there's been conversation of this already by Judge McJoynt on limitations, but that is what's in the rule. So it is worth a close reading of the rule because there's much more in some of the other areas we discussed that should be noted. But I can envision on the technology side a lot of problems. People are going to have to know how to use Zoom. They're going to have to know how to put their audio on. They're going to have to know how to put their video streaming properly. They may have low bandwidth, which is even a problem here today in certain places. They're going to have issues of interruption where maybe somebody will be testifying and then all of a sudden they break up. Those are real problems that are going to be challenges we're all going to have to deal with on a daily basis.
All right. Thank you, Judge Felice. Wendy, do we have any more?
And there's several more, but I think the last one to probably address is what if people believe they need more than 20 minutes for a pretrial? Is there an avenue to get more than one slot or to have arrangements for a longer hearing or pretrial?
Yeah, the old days, well, can I have double slot at 9:30? I think that's still available. You got to ask your judge. It's up to the judge. Do you want to let this case hog up your whole motion call for an afternoon? That's a judgment call that judge is going to have to make. But I don't see any harm asking the judge.
Some of these other ones, I think Judge McJoynt will end up sending you maybe some other questions to just sort of maybe send out some answers to the members outside of this forum since it's already almost 1:45. And just to make sure that we address a few more of these. I think Henry had a few announcements before. Judge McJoynt, if you have anything else.
Yes.
I do not. Thank you.
All right. Yes. Thank you, Wendy. And remember that to the extent that maybe there was a question that was asked but wasn't answered, or there are going to be other questions that come up. There's going to be a myriad of them. So as that happens, what we're going to try to do is, again, we're going to try to do another judges panel like we did today in place of the family law section meeting that would have taken place on Tuesday, the 19th. So hopefully we'll be doing this again and we can ask new questions, and you can submit new questions as they come along. You can submit those to me and to Vicki, please. So I would like to make some announcements. Just before I do, I would like to thank everybody who participated. President-elect Wendy Muslek, thank you very much. Vice Chair Vicki, thank you. Your Honors, all of you, thank you so much. Chief Judge Guerin, thank you for coming in and giving some extra announcements. We really appreciate everybody taking all the time today to come in, answer questions, and help all the attorneys through this. We really, all of us appreciate it. The announcements. Please note that the DCBA's installation and President's Ball, originally scheduled for June 5th, will now take place on Friday, September 18th. A small event to recognize the installation of Wendy Muslek as DCBA President 2020 to 2021. Officers and our new directors will take place, however, in June. Also, the DuPage Association Women of Lawyers installation, originally scheduled for May 28th, is now also postponed and will take place on September 24th at Arrowhead Golf Club. And then I think I've got one more. Two more, actually. The 2020 DCBA golf outing will be Wednesday, August 26th at Naperville Country Club. That's Wednesday, August 26th, Naperville Country Club. And the DCBA and DOL will be hosting a joint judicial reception on October 22nd, 2020 at Donata House. And look for those events on our DCBA website. And I'm sure Barb will have those up there. So thank you again to everybody. Unless anybody has any closing comments, we'll be signing off. And thank you also to all of our attorneys and attendees who submitted the questions and asked questions today.
Thanks, everyone. Bye.
Bye,
Thank
everybody.
you.
Bye. Stay well.